I'm not the one who will think about myself, my reputation, and leave a story incomplete. And to do that, I didn't have a team. I had to do what I had to do. Everybody has a choice to skip, but when all 42 skip together, it's like all 42 having loose motions at the same time. This advocate is handpicked by the judges. KHCAA is probably the most secretive organization that is working. There are the judges as a KHCAA president. There is a lot that you gain. There are government leaders who have private practice. A sitting judge has a law firm running in his name. Bar and bench relationship should be based on mutual respect. You respect me, I respect you. If you don't give us the respect we deserve, we will not give you the respect you deserve. If anybody thinks that I'm here for a record, no, it just doesn't mean anything to me. But I came here, I saw that there was a strong lobby, there was a strong nexus that was at work. And I've been able to subdue it for the last 2 years. This year, that structure needs to be dismantled. Once the structure is dismantled, it becomes extremely difficult for that lobby or that nexus to form again. So that is exactly the intent that I'm contesting another time. You see why I'm standing again for the third time? I've taken a great risk because it's easy that when you have earned yourself a name and a reputation, it's easy to say, okay, I'm done, I can walk out. But doing that, I fully know what I'm leaving behind. I'm leaving behind an incomplete story. I'm not the one who will think about myself, my reputation, and leave a story incomplete. At least I want to know that I've made an effort, and that is the reason why I stood for the third time. It's very clear, if an association doesn't take care of the welfare of the community, nobody else would. So all these associations which are political associations, they have become mouthpieces of their political outfits. For example, take the shifting of the High Court. ILU writes letter for every small thing. Will they ever oppose the shifting of High Court? Association should have is to protect the lawyers, protect the advocates. No, I never have a strategy. I just look at the people. I believe that lawyers are mature enough to make choices for themselves. It is still probably still a stepping stone to becoming a judge. And that is why there is so much of demand to be the president. But if you actually have to do things for your members, you will end up like me with the only thing that you earn is the number of enemies actually exponentially increases. These the judges as a KHCAA president, there is a lot that you gain, but I am not here to please judges. I am here to do what is good for the members, and that is what I am doing. To stay assertive, you need to ensure that your bread and butter is taken care of. I have different sources for my bread and butter, because of which I am able to do what I am able to do. You have elected me as your president, and the president needs to communicate clearly what is wrong with the system. And if all the judges boycott it, we need to point it out, because it was shocking, because it was unionization of judges. It has never happened anywhere in the country. I don't think any judges would have said no to any of the functions of the associations anywhere in the country. This time, not a single judge except for Justice Anil Narendran came in. And it is a very clear indication that there has been unionization, and I had to clearly tell the Chief Justice what it is. Everybody has a choice to skip, but when all 42 skip together, it's like all 42 having loose motions at the same time. Tell me, how many members would have signed such a letter? If I'm looking for the consent of the executive committee, I do not know how many of them had the courage to do it. Then I run the risk of sleeper cells. You need to maintain some kind of secrecy. You need to communicate clearly and assertively. And to do that, I didn't have a team. I had to do what I had to do. It's not about trust, it's about fear. You need the courage. You need the courage to stand up for what it is. I stood up. And I don't think there's any question of trust. No easy issues. Take annual day, for example. You are, for the first time, bringing in a subscribed meal, which has never happened. If you think it is an easy decision, it is not. It's a very tough decision. I took it. Take the settlement of the Shilpa case for the chambers. It has been running for 7-8 years. Somebody had to bite the bullet. I bit the bullet and I've got it settled. So decisions which sometimes what public perceives as against you is something which a leader has to take, fully knowing that the public perception is different. But ultimately, if it is for the benefit of the advocates community, you take it. So I don't think I have been choosy with the decisions that I take. This is the first time you had an annual day where you could identify each other. It is important that you have an annual day where you enjoy. All the previous annual days that you have seen, it has been a slugfest. It is important that you bring in some kind of system, and I brought in that system. It takes courage to take these strong steps, and leaders are supposed to take strong steps. I strongly believe that 95% of problems that lawyers face can have an end in the courtroom itself. If a judge behaves with you disrespectfully, all it takes you is just stand up and say it is not acceptable. When you don't do that, you expect the president to take it out in a reference speech. I think that it takes away the dignity of the occasion. And therefore, reference speeches are for an entirely different purpose, and it is not to abuse the judge. E-filing is an issue that I had taken up in a big way with the committee of judges and everybody. But the art of negotiation is this: how do you get the other side on the table? So you need to do something which brings the other side on the table. What would have brought them to the table? They would have been brought to the table if the advocates refused to give physical copies. It would have been immense drain on the High Court resources for it to take printouts of every petitions filed by advocates. That would have brought them to the negotiating table. Therefore, when I brought a resolution, that resolution failed, and that resolution was perfectly legal because there was 2 Supreme Court judgments which said that once there is e-filing, you cannot insist on physical copies. We had the law to our side, we had everything to our side, but the resolution still failed. Everybody knows who made the resolution fail. The All India Lawyers Union and the DYFI state unit ensured that the resolution failed. This whole idea about divide and rule, it is something that they say, yes, if you ask me whether there is a divide and rule, yes, there is a big divide and rule, but you have to understand where is the division from. As I told you that there are lobbies and there is a nexus, but these lobbies are not a single unit. These were different units that were functioning. After I came, what has happened is all these units came together. Therefore, now the divide and rule is this: all the lobbies on one side and all the other lawyers who have nothing to do with any of the lobbies on the other side. The lobbies don't need me, the other side wants me. And that is exactly who I cater to. I cater to people who are not in any of these lobbies. See, we give a lot of lip service to first generation lawyers, second generation lawyers. I have only one question. How many times have judges appointed first generation lawyers or second generation lawyers or lawyers who have no godfathers as an amicus or have been given commissions? No, these all go to particular hand-picked lawyers. All I am saying is, let there be a panel, let advocates perform, let them come out on merits, and let the judges choose from that panel and hand it over. So everybody gets a free, fair and equal playing field. That's what I'm fighting for. I have no idea how many committees are there in the High Court. But take, for example, the rule-making committee, where there has to be an advocate. So this advocate is handpicked by the judges, and the association has no idea what is he going there and doing. So if the lawyers have a need and they need certain things to be done, who are they going to talk about? Which is the lawyer that they can instruct? No, there is nothing. That is exactly why association needs to be given its due, and that is what I fight for. And 2 letters to the Chief Justice saying that the advocate in the rule-making committee has to be nominated by the association, because I get too many complaints from our community on certain rules. So if I need to put it forward, if I need to take it before the rule-making committee, I need to know who is our representative on that committee, and therefore take up these issues through them. But that is not happening because I have no idea who has been handpicked by the judges. KHCAA is probably the most secretive organization that is working. There are so many schemes that look so beneficial to lawyers, but remember one thing, every lawyer in that KHCAA has been handpicked by judges for a particular purpose. I don't think KHCAA is doing what it ought to do statutorily. They are bringing schemes, they are bringing things which are outside the statute. For example, I have no idea why anybody would get access to child victim. But even for bail matters where child victims are concerned, it is these people in the name of KHCAA who go and mediate, and there is serious allegations against one of these advocates saying that they have settled certain matters by taking money. How do you manage that? You can't do anything. And I have raised issues with KHCAA several times. Some of the practices that I saw in the Kerala High Court is something which is very typical of Kerala High Court. One is how the public prosecutors or the government pleaders behave in the court. I do not understand why should they have exclusive access to the judges in their court. They are, after all, another litigant before the court, and the same distance that the judges put with other counsels should be maintained with the government pleaders and prosecutors, but that doesn't happen here. Take Onam celebration for sure. When a judge celebrates Onam in his chamber, the prosecutors are welcome, but not the other lawyers. Why is it so? Is the judge and the prosecutor in the same team? So these are things that doesn't happen anywhere, and the prosecutors and the government pleaders are supposed to tell the court what the law is or what the facts is. But here it is not so. They become a mouthpiece of the government. So I believe that some of these practices in the Kerala High Court that I see is very typical to Kerala High Court. Even the Supreme Court is on record saying that the position for government pleader has to come from merit. But we are having this practice that whenever the government changes, the government pleaders change. So this has been a practice. It needs to be taken care of. We need to fight a legal battle if need be. But this is something that we should seriously think about. It should not happen that political parties should nominate the government pleaders and prosecutors. In courts outside Kerala, I have many times seen the moment a government pleader becomes a mouthpiece of the state, the judges come down very heavily on the government pleader, saying that this is not what is expected out of them. I have never seen that happen in Kerala, even when the government pleaders and prosecutors are explicitly acting on behalf of the state as its mouthpiece. There are government pleaders who have private practice. When their private clients are there before some other courts, they call up the government pleaders in those courts and ensure that they get orders that they want. This is one way in which this lobby and nexus work. There is the second lobby and nexus that works where it is the children of judges practicing in the courts. So when you have 12 to 15 children of judges practicing, again, they also get priority. And the third one is the most blatant one, and that is one where a sitting judge has a law firm running in his name. Now please tell me, a client when he comes, who will he choose? He will first go to the office of the sitting judge if he can afford it, or else they will go to a government pleader who is running a private office, or else they will hire one of the children of the judges. So who speaks for the common lawyers who have none of these? Majority of them are people who don't have any of these connections, don't have any godfather, and what I have done for them is the association is their godfather. One thing that I saw in the bar in Kerala is the absolute submissiveness of the bar. I don't think there is another place where there would be a law firm that is run in the name of a judge. Then there are children of at least 13 or 14 judges practicing in the courts. How do you expect justice? The restatement of values in judicial life says that a judge should not hear his own close relative, and therefore the judges' children would not come to their court, but they are going to all other courts. And when there are 13 or 14 judges who all have their children, how can justice be seen to be done when these children get orders from other courts and other first generation lawyers look helplessly at what is happening, but nobody is having the courage to stand up and speak about it? I have taken it up. So this is what it is. I don't give lip service. I stand up, I say this is injustice, this needs to be taken care of. Always there were lobbies that were functioning in the court. There was this nexus of certain lobbies to certain areas, but now what has happened is 2 years they have been subdued so much that all these lobbies have kept aside all their differences, have come together, and the only aim that they have is to ensure I am out of the office of the president. That is why there is this kind of vicious attack that has happened this election. If you ask me why I don't respond, I believe that advocates are mature enough to understand this. Otherwise, no other candidate has ever seen such level of vicious attack and the manner in which this is blowing out of proportion. But it's not overconfidence that makes me say nothing or remain silent. The only reason why I remain silent is because I strongly believe that all the members see through this, and all that I'm trying to get here is a level playing field for all lawyers. Whoever comes inside a courtroom should be treated equally by the judges, and that is my ultimate aim. There has been a lot of noise being made about the KHCAA stopping the subsidized meal scheme. I do not see lawyers as refugees. I don't want to treat them as refugees. What I want to do is not give them a subsidized meal at 10 rupees. What I would want to make them capable is they should be able to afford a meal for 100. So we don't even speak about these subsidies, but we make them capable enough to earn their livelihood. I do not see lawyers as refugees. I don't want to treat them as refugees. They are entitled to dignity and they should have their dignity. So if you ask me, I will easily help them, because all that is needed is these children can easily get the stipend from the Bar Council of Kerala, which is their right, a statutory right that has been given by the Bar Council of Kerala. The ones who are making too much noise about pulling back of the subsidized meal scheme is the ILU, and it is ILU who is running the Bar Council. If they are really feeling out for these people, all they have to do is ensure that all of these people are given what they are entitled to, and that is a monthly stipend of 5,000 rupees. I know that this election campaign is getting dirty, where food and drinks are being given to young lawyers. I will never indulge in that, because while I was in Bombay, I used to stay in the house of a very senior police inspector who never used to drink liquor from any of his any of those people who wanted him to work, because he told me that the value they give to you in their entire life is the number of pegs that you've had. I don't want to value any young lawyer with a number of peg or certain amount of food. I want to give them their dignity, and that is exactly the reason why I don't indulge in any of this. It is not just that. The junior bar can be helped in many ways. I have tried my best to bring them together, but somehow I have not been able to organize them. But my whole idea is, if you are willing to work, the work will be there. How will the work be there? I'll tell you this. There are at least 100 companies in the Techno Park and the Info Park out there. Everybody wants training on labor laws, on POSH Act, on sexual harassment, and many other areas. So if we develop a research center where we develop modules for all these training, we can provide this training for a particular cost. There are lawyers in metros like Bombay, Delhi, where they want research help. So if you have a research center where there are juniors willing to do research on some matters, all we have to do is connect them with these lawyers in metro who will be more than happy to engage with the juniors, and that can be a source of their income. And these are all schemes that can be brought in, provided the junior bar comes out and are willing to work and organize themselves. Then this can easily be done. Manner in which advocates get attacked, particularly what is not acceptable is when police don't respect advocates. There was an instance where a lawyer was handcuffed and kept inside a cell, and at that time I moved a contempt petition, and I was not the president. But unfortunately that matter slipped off because the concerned lawyer refused to file an affidavit. But I have seen how this thing spans out. Lawyers are normally happy of calling for a strike, getting the police officer suspended for 10 or 15 days, and in 15 days everybody forgets about what has happened. I have a very different way of dealing with it, and one of those is the example of how we dealt with the Alatur matter. There was a young lawyer who was abused in the police station, and we ensured that we fought a matter, and that policeman was found guilty of contempt. And I believe that this is far more effective than having a policeman suspended, because suspension means nothing to them. But when you have been convicted for contempt, that remains not just in your minds, but it remains in the minds of every policeman. So that is the way I believe you need to take care of increasing attacks on advocates from police. And there was the other case in Ramankari where an advocate was pushed around for arresting one of the clients. All that the advocate did was he asked for a copy of the warrant, and the police misbehaved with them. We ensured that we took up the matter in a writ petition, and the court came out with the guidelines as to how police should carry out arrests within the court premises. The police association went and filed a SLP in the Supreme Court, and fortunately the Supreme Court said that they are considering similar guidelines at the national level. The letter I wrote to the Chief Justice seeking an inquiry into a potential leak of judgment has created an uproar. But what people forget about is this, that whenever I write letters, if it is not confidential in nature, I myself ensure that it is circulated in the KHCAA's official group. I have not given it because it was a confidential letter. that letter was leaked by somebody somewhere and has created a furore. But the fact is this: I receive an anonymous letter which says that how a particular judgment would be pronounced. It is an anonymous letter, so the first tendency would to ignore it. But the only reason why I did not ignore it is this, that no person in his sane mind will ever disclose a judgment yet to be pronounced with his name. And for having understood this particular aspect, I thought a limited inquiry was required to ensure whether there has been a leak, because if there has been a leak, it needs to be plugged. Therefore, I forwarded that letter to the Chief Justice only to ensure a limited inquiry on whether the judgment was leaked because of systemic issues. But this letter leaked from the association for some reason, and everybody accused me that I was even the author of that letter. But the letter, though dated 2nd of December, was received by me on 5th of December, and 5th was the last day of filing nomination. I was busy, and on 6th I went to the district court in Ernakulam and district court in Paravur, because of which I did not open the letter. I opened the letter on Sunday, and I immediately wrote this limited request for inquiry, and this letter was given to the Chief Justice on 8th of December at 10 a.m., much before the pronouncement of the judgment. So I don't see that there should have been the issues that now seems to have arisen. But in many ways, whatever has happened for the good. Now that there is an investigation that is happening as to who sent this letter, now it is very clear that I was not the only recipient of the letter. This letter was sent to former judges, sitting judges, and probably to the office of the Chief Minister, to the Chief Justice, to the Governor, wherever, it needs to be inquired as to who did it. And for me personally, I would like to know who leaked the letter from the association. What have I achieved in 2 years? I don't want to name what I have achieved in terms of the Dandapani lane or a canteen or a library that has been renovated. I'll tell you what I have achieved with my own experience. When the Mary Joseph incident happened, I went with a complaint letter into the association room. Almost all members of the association were there, and none of them were even ready to receive a letter against a sitting judge. They were so fearful. Then came a resolution brought in by 2 members, because of which they formed a subcommittee, and they put me in the subcommittee. And when we were discussing what is to be written, I said I will draft it myself. I drafted that letter as a member of the subcommittee and gave it. And I couldn't still believe that this could have happened, in the sense that the then president, acting president, he was reading through the letter and saying this word is strong, that word is strong, and he was, no, I can't write those words to the Chief Justice, and he was cutting those words. It was a committee that did not even have courage to write one proper letter to the Chief Justice, and that is what I have changed in the past 2 years. The association room is open for anybody with a complaint will be taken care of. We have had many examples of what has happened, but I have ensured that every lawyer is made confident that they are not alone in any fight where justice is with them. First instance was when Jayakumar Nambudiri came with a complaint against Justice Badruddin. Immediately we wrote a letter and for some days the conduct of Justice Badruddin was a lot better. And thereafter, we all know what has happened when the Sarita incident took place. We have never backed out from dealing with genuine cases. There was another instance where one particular judge, in fact, told in the open court that he will initiate contempt, but I went to that court. After ascertaining the facts, I wanted to make sure that that advocate is given a proper defense, and by evening the contempt was not anymore there, and instead the word avoid was written on the order sheet. So I have never backed away in supporting any member if he has been dealt with in a wrong way by any court. And it is important for me that advocates are having a free mind when they stand before any court and argue. And that is one thing that I have achieved, and to gain confidence of those lawyers is what I believe is the biggest achievement I have made in the last 2 years. KFWL is another organization which I would never have had an issue, but the manner in which they dealt with junior lawyers, even senior lawyers in the ladies' room is something that could not be justified by any standards, because the ladies' room is for all ladies, and KFWL had built a small part of it for themselves, and they were not allowing other lady lawyers from accessing that room. So it is something not acceptable, because once a room is allotted to the entire lady lawyers, it was unjustifiable for them to use it for their purpose. And that is exactly the reason why that day I had decided to ensure that the door of the room itself is to be taken, because you need extraordinary measures to deal with extraordinary situations. Because had we kept a door and only removed the nameplate, we would have achieved nothing. To ensure everybody has access to that room, the door itself had to be removed, and we removed it. And KFWL was actually a lobby group. What they would do is about 30 to 40 lawyers who were members of KFWL were controlling the rest. So today, if you ask me, why have not been lady judges coming out from High Court of Kerala? It is because of this politics, this dirty politics. If at all you have to be a judge or to be nominated by the collegium, you can take the cases of those ladies who have been recently looked at as judges. They are in the executive committee of KFWL. KFWL was somehow operating to ensure that they give some kind of sanctity to these people who are not meritorious by any standard, and push them to judgeship. And take the simple case. Just imagine a lady lawyer coming to the KHCAA and asking for a locker facility. As a president, I have to tell them, please go and be the member of KFWL first, who will then allot you a locker room. That is not acceptable, and that is why I had to take those extreme steps that is required, and those extreme steps were required only to ensure that all lady lawyers have equal access to the ladies' room. If anybody thinks that the bar and bench relationship has deteriorated, I will tell a very clear no to it, because bar and bench relationship should be based on mutual respect. You respect me, I respect you. It's a two-way bridge. It's never one way. For all these years, I have always found that the bar and bench relationship has been a one-way relationship, where the judges were controlling. There was this idea where whatever the judges do, you just go and respect the judges. But that is not acceptable to me. If they don't respect me, I will not respect them. It is as simple as that. I don't see judges as lords and the advocates as slaves. We are equals, and if you don't give us the respect we deserve, we will not give you the respect you deserve.